Good morning. I had another question arise on the FPS internal memo 2018, and the question wasn't addressed at me, but I figured it was a really interesting question, so I'd tackle it as best I could. It arises on page 3 after the regulation and application section. It says, for example, SSA has rules that prohibit photography and videotaping in its spaces. And the obvious question would be, what possible rules do they have? So this is the CFR Title 20, Employees Benefits, Chapter 3, which is Social Security Administration, Part 422, which is Organization and Procedures, Subpart J, which is Protecting the Public and our personnel to ensure operational effectiveness. This is their entire list of prohibited conduct. It is 4 things. Basically, you can't threaten or physically assault somebody, and you can't engage in disruptive behavior. That's it. And I don't believe that photography in and of itself, without anything else, would be disruptive. Now that I've said that, I do want to mention that I did look at about 20 different Social Security offices, and all of them were located on GSA property. Now, there's probably thousands of Social Security offices throughout the country, and I'm not going to look them all up. So do your homework, but you got to remember that if they are on GSA property, then the rules in 41 CFR 102-74 apply to all property under the authority of the U.S. GSA and all persons entering in or on such property. Each occupant agency shall be responsible for the observance of these rules, the 102-74 rules and regulations. And again, under 41 CFR 102-74.420, it does say that you do need the permission of the occupying agency in order to film inside, whether for commercial or non-commercial purposes. It does require the permission, either oral or written, depending. So don't believe that you can just go in willy-nilly to a Social Security office and film, because their regulations don't appear to prohibit filming. Now, I was banging my brain against the keyboard trying to figure this out last night, and I stumbled on HIPAA, or I thought about HIPAA, because people go into the Social Security office for disability payments and Medicare. So this is Public Law 104-191. This is the HIPAA law. It's insanely long. It is 168 pages long. I won't drag you through it. The relevant codes that I pulled out of it, this is 42 USC 1320D. This is definitions. We're in 42, which is Public Health and Welfare, Social Security, General Provisions, Peer Review and Administrative Simplification. So we are in the Social Security section. So just remember that. Part C would be Administrative Simplifications, and we're in 1320D. Health plan is defined as a Medicare. Part A, B, C, or D of the Medicare program. Medicare is part of Social Security, therefore any place where they're talking about Social Security would be subject to the rules on confidentiality. These are the penalties for violating the rules of confidentiality, where you allow confidential information to leak out. There are not only fines, but there's also the potential for civil action, etc. So there are punishments for it, for the health plan provider to allow confidentiality to be broken. These are kind of codified in 45 CFR 160 et sequitur. It defines covered entity. Covered entity means a health plan, etc. And health plan again refers to health plan again refers to Medicare. So if they're dealing with Medicare in that office at all, then HIPAA rules would apply to them. Again, 164.302, this is applicability. A covered entity must apply with the applicable standards. And general rules, covered entities must ensure the confidentiality of all electronic protected health information. So they have to make sure that you're not able to film or view the screens, the computer screens, while they're discussing things with the people in the office, etc. And they probably also want to prevent you from electronically recording any conversations. I believe that would be a violation as well. So anyway, I believe HIPAA does apply, or at least a creative prosecutor could make HIPAA apply. Because HIPAA does apply or should apply, they do have to ensure the confidentiality. Because they have to ensure the confidentiality, they can restrict photography. I hope that makes sense. I do hope that you are also mindful that eavesdropping statutes will probably also apply. So you may be liable on a lot of different levels for audio or video recording people having conversations that are private in nature like that. And you're going to say, well, they're in public. And I don't believe a court's going to think that having a discussion with a Social Security office person away from everybody else means that they don't have some expectation, some reasonable expectation of privacy in that conversation. But that being said, be careful out there, have fun, and happy auditing.